How to make sure your living trust doesn't fail. In today's webinar, we're going to talk about funding your living trust. You've gone to all this trouble to set up your living trust, your revocable living trust. You want to make sure that it's going to work when the time comes, but there's a critical piece that you want to make sure that's included. So hi everyone, I'm San Diego and now Salt Lake City Trust and Estate Attorney Christina Hess, and I'm so excited to share this content with you because it's really important. It's really important to make sure your living trust doesn't fail. So this is about how to transfer your assets to the trust. Because the truth is, for years, there were lawyers that were setting up living trusts and they were saying, okay, everybody needs a living trust, but then they weren't getting the trust funded. They would maybe transfer the house to the trust, but then the clients were left with no instructions or really not knowing what to do to make sure that their plan was going to work. And then 9 times out of 10, they ended up in probate court. So a little bit of background about me. I grew up in San Diego. I'm the mother of 3 amazing sons, and that's my husband. And I went to UC Berkeley School of Law. Now it's known as Berkeley Law. I've been an attorney for over 24 years and I've helped hundreds of people set up estate plans. And I can tell you that this is a really important subject that we're going to talk about today because I want to make sure that your trust is going to work when the time comes. So I established KR Hess Law in 2009, and our mission is to help individuals and successful families create lasting legacies, empower their generations, and inspire generosity through legal planning tools. So we want to make sure that your trust is going to work when the time comes and that you are going to leave an amazing legacy behind. So one of the ways to leave an amazing legacy is to have your legal house in order and to make sure that your trust gets funded. So what is a trust? If you're here and you're like, hey, I don't even know what a trust is, your trust is a legal contract that manages your assets not only while you're alive, but then after you're gone. That's why we call it a living trust. That's not a legal term. It's actually a revocable inter vivos trust would be the more technical term for it, but basically everyone calls it a living trust because this is a revocable trust that you can amend, you can change, you have 100% control over while you're alive, and then when you're no longer here, you'll have trustees that will manage the assets. So what are some of the terms that are used with a trust? There's a grantor of the trust, that's the creator of the trust. There's other names for a grantor, settlor, trustor. So those are all synonymous, grantor, trustor, settlor. That's the creator of the trust. And then the person that manages the assets is the trustee. So while you're alive, that's you. Or if you're married and it's a joint trust, in California, we do joint revocable living trust. For married couples, that's going to be the husband and wife. They're going to be both the grantors and the trustees. They're going to manage the assets in the trust. And then third, you're going to have a beneficiary. So during your lifetime, again, that's going to be you or you and your spouse. So this is your trust. It's a legal document. It's a contract that you create. It's an agreement between you and your successor beneficiaries or contingent beneficiaries and your successor trustees. So it serves 2 purposes. One, you want to make sure that you're taken care of if you're ever incapacitated. And 2, you want to make sure that your loved ones are taken care of while avoiding probate court. No one wants to go through probate. So that's why if you're watching this video, chances are you've already set up your trust. So congratulations, good job. And now this is for our clients and also to educate others. We want to make sure that your trust gets funded. So we like to joke that probate's a lawsuit you file against yourself with your own money for the benefit of your creditors. Not a good use of your money. So you want to make sure your trust avoids probate. It's a court system. So in San Diego, we have a probate court and there's 3 probate judges in all of San Diego County, and we have a very massive county, goes to this one court downtown with 3 judges. And right now, 2024, I literally filed a probate case on Monday. Our hearing date was in 6 months, which is crazy. It's incredibly slow. It's expensive. It's about 5% of the gross fair market value of the assets, and everything that gets filed in the court is public. So you want to avoid probate. So That's the bad news. The good news is, and that's why you're here, once you've set up your trust, the important thing that we're talking about today is you want to make sure that it's fully funded. Now, this is a term of art. What does it mean to fully fund your trust? So, the first thing you're going to do, and for all of our clients, we have a funding coordinator, and he will literally take the inventory of assets and then go line by line. And we want to list every asset in an inventory in an Excel spreadsheet, and then we send that to our clients to confirm that we have all of the assets listed correctly. And then when they come in to sign their plan, we're going to give them funding instructions. So what are these funding instructions? I'm glad you asked. I'm going to go over those with you. So first of all, you're going to do deeds. The deeds are for any real property. So you're going to execute a deed transferring your interest in your real property to your trust. Now, your house most likely is going to go into your trust. If you have rental properties, maybe you have an LLC because you want some asset protection, you want to increase your income tax deductions. So an LLC might be the document that you are that might be the entity rather that we're going to transfer your real estate to. So a lot of our clients have real estate investments. Some of them will put them in their trust, but that's a separate conversation. But the important thing is you want succession for the real property, and then you also need to be mindful of property taxes. So we'll have subsequent webinars about those topics. But to get the real estate into the trust, that's the critical thing. You're going to sign a deed, put the asset, the real estate, the real property into the trust. We'll record that with the county where the real estate is located, and then voila, your real estate is funded. Bank accounts. So a lot of our clients will have bank accounts that say, if you look on the left-hand column of the screen, it'll say Bob and Sue Smith. So what you want to do is you want to retitle your bank accounts so that it says Bob and Sue Smith, trustees of the Smith Family Trust. So you need to make an appointment with your banker, bring in your trust or your trust certification, and then they will retitle your accounts for you. So that's important. Now, some people might say, Christina, I have a really small bank account that we only pay bills with. Do I really have to put it in my trust? And I might say to them, no, you could keep that account out of your trust. But the rule in California is if you have cumulative assets that total $184,000 and they're not in your trust, then you don't avoid probate. So if you've got some small checking accounts, savings accounts, you don't ever have a big balance, you're paying bills, you want to leave those outside of your trust, that's up to you. That's perfectly acceptable, but just be aware if you pass away, those accounts will be frozen and no one will have access to them for 40 days. So while we can pour them over to your trust, there will be some time delay. So the best course of action is to put the accounts in the name of the trust with your successor trustee. Investment accounts. So this is after tax investments, your stocks, your bonds, your investments that are not retirement. So this is your Schwab, your Fidelity, your TD Ameritrade, whatever those investments accounts. I've got a SoFi account, for example. You're going to retitle those to your trust. Now, SoFi actually doesn't let you make trust accounts, so you will want to have beneficiaries on those. But Schwab, Fidelity, all the big brokerage houses, they will allow you to re-register your account to the trust. You literally can Google Schwab transfer investment account to trust, and then the form will pop up. You can fill that out. I think you can even submit it online, and they will help you re-register your account. If you work with a financial advisor, then they will definitely help you. So what we do for our clients is we send the financial advisors the certificate of trust and say, please help the client re-register the account. And they routinely do that. So that's bank accounts and investment accounts and real estate. So now let's talk about, so those are all ownership changes. So those classes of assets can be owned by your trust. Let's talk about classes of assets that are not owned by your trust. So retirement accounts, for example. This is a perfect example of an asset class that is going to stay outside of your trust during your lifetime. So what do I mean when I say retirement accounts? I mean your 401k. your 403b, your IRA, your Roth IRA, your retirement annuity, all of these pre-tax savings accounts for retirement stay outside of your trust during your lifetime. And legally, you don't want them to go into the trust because that would be a taxable event. So they stay outside of the trust during your lifetime, and legally they're going to pass by who you have designated as the beneficiary on file. So for example, with retirement accounts, there's tax implications. Typically, your spouse is going to be 100% primary beneficiary. Then your secondary beneficiary, and this is an important thing. A lot of people, especially if they don't have children, they might have their spouse as their primary beneficiary, but then they have no contingent beneficiary. And I have seen this happen a lot. People have been married for 40, 50 years. One spouse passes away, chances are the second spouse often will pass away within a relatively short time. And by then, they're elderly, they might not be as savvy to update the beneficiaries, and then the accounts could go through probate. So it's really important on the beneficiaries. You want to have a couple of layers. So you're going to have a primary, which is the first layer. So 100% spouse, for example, and then you're going to have a secondary or contingent beneficiary. That's usually going to be your trust, or if you have adults, it could be individuals. After the Secure Act, after spouse, except for certain exceptions, like your kids, for example, they only will have 10 years. If they're over 24, they're only going to have 10 years to take all of the account out. So the trust may or may not be the beneficiary at that point, but that would be something that you would consult with your attorney, because we'll give you very specific instructions about what's the best for your particular situation. And note, if you put the trust as a beneficiary, it's very critical. The trust has to have specific language in it so that the trust qualifies as a designated beneficiary under the tax code. A lot of financial advisors will tell their clients, don't ever put the trust as a beneficiary on a retirement account. And the reason they say that, it's not necessarily good advice, but the reason they say that is because a lot of trusts might not have the proper language to make sure the trust qualifies as a designated beneficiary. So you do need to be careful, make sure you have a well-drafted trust, and make sure that if you're going to put the trust as a beneficiary, it's got this special tax language. All right, so what are some mistakes that could happen? People get divorced and then they forget to update their beneficiaries. Very important. Or maybe there was a case recently where the mom, I believe it was, she disinherited one of her children, and the attorney changed the trust and the will, but they did not advise the client to check their beneficiary designations. And so that child was still a beneficiary on certain accounts. So that was an unintended consequence. So you really want to make sure when you're leaving a legacy and you're going to this, you're doing this amazing work to make sure you've worked hard, you've accumulated wealth, you're doing all the right things, you set up an estate plan, and then you really want to make sure your assets go to the people you love in the way that you want, in the best way possible. So a lot of times clients will want to, they're generous. They want to leave some assets to charity, maybe their local church, maybe feeding the hungry, maybe water in Africa. There's so many amazing causes out there. And your retirement accounts are a really great place to do your charitable giving. Why? Because they're pre-tax for you, except obviously not Roth IRAs, but they're pre-tax for you. But when the asset comes out, it's going to be taxed at the ordinary income level. Same goes for your beneficiaries. They could be losing, depending upon their tax bracket, they could lose 40 or 50% to taxes. So charities are great beneficiaries on retirement accounts because they're not going to pay the tax. So if you do have charitable giving as part of your plan, this is a good place to look. Instead of putting them in your trust, instead of putting them in the will, put them in the designation of beneficiary on your retirement accounts. Life insurance. So life insurance, now, if you do not have a taxable estate, meaning your assets are under $10 million and they're not likely to go over, if you're married, to go over 12 million, or if you're single, to go over $6 million, then your revocable living trust can be the beneficiary of your life insurance. So your trust should be 100% primary beneficiary on your life insurance. If you have a taxable estate, i.e., you're going to have assets if you're single over $6 million, or if you're married, you're going to have assets over $12 million, or you have assets over $12 million, your life insurance, you really want to set up an irrevocable life insurance trust. You want to get those assets, that death benefit, you want it to pass outside of your taxable estate. So this is the easiest way to remove an asset from your taxable estate. So I'm not going to go into a lot of detail because that's beyond the scope of this webinar. But if you have any questions about that, be sure to message me and I'll be happy to explain. All right, assignments of interest. So let's say you do have an LLC or you have an S Corp or you have a business. How do you align that with your estate plan? How do you align that with your estate plan? All right, I'm just going to finish this other slide and we'll come back to that one. So bonds, stocks and bond certificates, this is a big one that people don't actually fund to their trust. And the reason for that is it's a little bit of a pain. So let's say you got a treasury bill or a T-bill. T-bills were paying almost 10% when interest rates were really low. But people take them in their individual name instead of the name of the trust. And then it's a real hassle, or some older people have actual bond certificates. They bought bonds and they've got the actual certificates. You have to mail those into Treasury Direct unless your local bank will exchange them for you. So it's best just to put it in the name of the trust. It makes transferring them on death so much easier. And then personal property. This is tangible personal property. So this is your stuff. This is cars, artwork, jewelry, boats. This is anything that's meaningful. So if you have heirlooms or things that are really sentimental, special paintings or jewelry or artwork that you want to make sure go to a certain person, you can incorporate a personal property memorandum and list who gets it. If it's very valuable, you want to list that in your trust itself. But then we're going to do a general assignment of all your personal property to the trust and then give your trustee discretion to divide it among the beneficiaries. Okay, so that goes for the things that you want to transfer to the trust and what you need to do. Now let's go back to this business interest. So LLCs and business entities, what we do is an assignment of the interest to the trust. We want to review the operating agreement, review the bylaws, make sure there's no restrictions, and then make sure we follow the mechanics of what's in the document to transfer to the trust. And then we want to get those assigned to your trust so that they don't go to probate. So it's important to look at that as well. Now, if you have a larger business or even a small business, but you've got partners or there's more than one of you that's unrelated to you, then you really want a buy-sell agreement or you want a shareholder agreement or you want something besides to make sure that you've got succession in place for your business. But for your smaller entities, you will most likely assign those to your trust. Okay. So what are some things that you may not want in your trust? I already talked about retirement accounts. Those do not go into the trust during your lifetime. They stay by themselves outside of the trust. If you retire or you're retired, you take your required minimum distribution, also known as an RMD. You take that every year and you make sure your beneficiaries are updated. Stock options or incentive stock, 1244 stock, unvested options, those do not go into the trust. Your interest in professional corporations. So I have KR Heslaw PC, which is a professional corporation. Now you can assign your professional corporation to the trust, but you have to have specific language. The State Bar of California, for example, requires that our bylaws have specific language. They require certain provisions. The stock has to be owned by a licensed person. And if you die, there is a 6-month grace period, but that's an important caveat. So we want to make sure that if you're going to assign that stock to the trust, that you do so carefully. And then maybe you have someone in your profession who could step in the event you died as your practice management person who's authorized as a practice manager to handle the transition of the business upon your passing. So that's an important caveat as well. And then you want to make sure your trust is a treasure legacy chest. I love this because your trust can actually set up the next generation for success, and it can go for, in California, 2 or 3 generations. In Nevada, it could go for hundreds of years. In Florida, it could go for hundreds of years. But you can set your trust up in such a way that it can continue down the family line so that each generation could benefit from this trust. So stay tuned for another webinar on that topic. But this has been all that I have on funding your trust. So hopefully this has been helpful to you. If you have additional questions, if you're clients of ours, you can always email us. We'll help you fill out forms. We're here to give you unlimited guidance on making sure that your trust is fully funded because it's so important. We want to make sure that your trust is going to work when your loved ones need it and it doesn't end up in probate court. This is really critical, and that the legacy that you intend to leave behind is fulfilled. So again, this has been Christina Hess, San Diego's trust and estate attorney, on how to fund your trust. Talk to you soon.